list fresh admission item number 1.
May I please have it? Minor, it is a matter relating to the rescue of minor garment who has been kidnapped by the opposite party number 4. Minor, the petitioner has approached from pillar to post of the state authorities for getting only time and some assurance, nothing else.
What are you doing?
My lord, the police is taking sincere steps, my lord.
Why is the superintendent of police?
My lord, personally, the IAS is present, physical present.
My lord,
No, there was a direction in the last date that the superintendent of police
Yes, my lord. Virtually,
is he present?
yes, virtually present, IAS is present.
So let us connect to the superintendent of police.
Yes, sir.
Yeah. Okay, no.
the petitioner is also present.
Disconnect.
It's a minor. So the occurrence in question took place as per the first information report. It is on 21/2/2024. You are the investigating officer. Yes?
Joint extra.
You have come to visit Cuttack or what? To see the Millennium City?
My lord, petitioner's wife and his two minor child also kidnapped by many unknown person, my lord, since 27 July 2024, my lord, at about 6:30 p.m. my lord. My lord, the police were registered a missing complaint, my lord, on dated, my lord, 2/8/2024, my lord. Since date, no.
What are the cases pending between you and your wife?
No, my lord, no case pending, my lord.
In family court, there is no case.
No, my lord. No instruction, my lord.
Please tell us clearly. There is no case under section 498 against you.
My lord, I have no instruction, my lord. I have taken instruction, my lord.
My lord, this is the biggest matter, my lord. The wife, she is serving at some hospital as staff nurse. There is a husband-wife dispute.
Yeah.
And this is application by wife on her own will.
She left.
Yes, ma'am.
She left the matrimonial house.
How do you say so?
Yesterday over phone I got instruction from the IAC.
Then why are you not making the appearance of this lady and let her file an affidavit so that it can be disposed of? If she on own volition has taken away and left the company of her husband and staying somewhere else, and the recourse is available to him, taking the shelter of the family courts, he can file restitution of conjugal right petition, or for the custody of the children, he can file appropriate application. But for that, we have to just give the affidavit of that.
Only the
IAC will file the affidavit.
That is his obligation to produce a report. There are the way to say something that is very much important. If you have contacted the lady,
No, the IAC.
or whatever, it means your officer. In the legal parlance, when the word you is used, it does not mean personally you. It means your client or anybody who is instructing
You are
you.
representing the state.
So when you say that your officer has already communicated to you that she has voluntarily left the matrimonial house and living some elsewhere with the children, then where is the difficulty of producing the lady itself? This is a habeas corpus. Let her come and say, there is no difficulty. She has a right. There is no difficulty. She is a major person.
Next week it can be done.
So that I will submit it.
Record that what he says and then produce.
This application has been filed by the petitioner, Trilochan Pradhan, with a prayer to
then it's all right. You're not, I am challenging Annexure 14.
What is that, madam?
Annexure 14, the order passed by this honorable court. Dated 29/11/2024.
Yes.
My lord, certain background is required to be placed before your lordships in order to know the case. My lord,
You
petitioner,
had earlier approached the court.
yes, I have approached this
Then-
honorable court. My lord, I have approached this honorable court when my representation was not attended to. And this honorable court was pleased to direct me to file a detailed representation before the authority. Accordingly, I have filed a detailed representation before the authority and it was rejected, for which I came before.
But the apex court has also rejected.
My lord, apex court, that is the issue before your lordship.
What?
Apex court, my lord, what has happened, certain background is necessary to be placed before your lordship.
No, the only observation was that there cannot be any, debate on
Yes.
that the appointment in violation of the rules are always regarded as an illegal action.
Yes.
But ultimately, the special petition was
My lord,
dismissed.
specially
That means there
petition,
was no violation.
my lord, specially petition was relating to some other thing. But right now I am having some other cause of action. My lord, there was a rule in 1983 relating to appointment of livestock inspector.
Yes,
According to the said rule, minimum qualification was matriculation with
yes,
other training.
yes.
And in 2004, an advertisement was issued for recruitment of the livestock inspector.
Correct.
But in between, what has happened in 1997, the rule was amended and the minimum qualification which was earlier for matriculation has been enhanced to +2.
Correct.
Yes. Soon after the advertisement was issued, the person, those who are having matriculation with training, they approached the learned tribunal, challenging on the ground that they may be allowed to participate in the advertisement.
When the recruitment process was initiated.
Recruitment process was initiated in 2004. That is
Four.
relating to that.
This relates to 2004
21. No,
recruitment
this relating to 2021.
21
Yes.
recruitment process. Now,
Yes.
in 2021, the
No.
minimum educational
Qualification.
eligibility criteria is +2.
Plus 2.
+2.
Yes.
So are you a +2?
Yes, I am a +2 since 1997.
That is immaterial.
No, my lord, that is
Right.
relevant in view of the fact that in 2004, the advertisement I want to participate, and I was not given a chance because the case was pending before the Learned Tribunal, thereafter this Honorable Court, and thereafter Honorable Supreme Court.
Yeah.
So I could not get a chance to enter into.
You want an age relaxation? Is there any power for age relaxation?
My lord, there is, my lord.
Tell me, is there any power reserved in the rules for age relaxation?
No, there is no.
Can it
But-
be done
My lord, that.
in absence of any?
My lord, for which I am before your lordship, but no fault of mine. My lord, for no fault of mine, I have been deprived of. Although I am having the requisite qualification, my name was referred for
No,
appointment.
a specific observation has been made
Yes,
by the Honorable Supreme Court that
Yes.
you do not have the requisite qualification as per the prescribed rules.
my lord, that is with,
If you think,
With
if
respect,
according
I
to,
say.
just a minute,
yes,
if you, according to you, this has been wrongly recorded, let us say,
yes.
then the better course is to approach the said court
My
and
lord,
say that this observation is factually incorrect.
my lord,
In a
that-
review
that-
petition,
my lord, that has.
Yes,
they should have approached the Supreme Court in a review petition.
My lord, that has not been done. That has not, curative petition only could have been done at that point.
AIR 1982 Supreme Court, State of Maharashtra versus Ramdas Srinivas Nayak. What my brother says is the Supreme Court says the same thing
Yes,
in that judgment. Probably
my lord.
page 1243, if my memory does not betray me.
When the matter is fresh in the mind of the judges, so if there's something has been wrongly recorded, it should be brought to the notice of the bench.
My lord, my submission before your lordship is, can it be a precedent? Can it be a precedent?
And the only thing is you may have a qualification, you may not have a qualification. Now, when they have now started the recruitment process in 2021, now you have crossed the maximum or the age which is prescribed there. Can the court issue a mandamus relaxing the age
My lord,
so that you may participate in this? If you have already crossed it,
my
cross it.
lord, in that regard, my submission before your lordship is that one of the person who stands on the same footing has already been given appointment.
Oh, can an illegality be
My-
perpetuated
my
for
lord,
all time to come? If there is an illegal, then what can be
My
done?
lord, my lord, I am having the qualification. I have been
But
deprived
you
of
do not have the requisite age.
requisite age because of the situation for which I should not be blamed.
The judgment
My lord,
of-
Does not impose against her.
if your lordship allow me, I will. Can,
We are allowing you, we are not disturbing you. We are listening to your argument carefully and
Sir,
with all
madam, only
patience.
one question, can the age bar be relaxed?
My lord.
That's the only question which is involved here. You may have all the qualifications, but not the age.
my lord, then question is, my lord, whether my case has been considered by the learned.
Can you go back? Then the
No, no.
Supreme Court judgment will stare at your face.
My lord, Supreme Court judgment will not stare at my face because, my lord, that was relating to 2004 and the order passed. The rule, I have to follow the rule. I am also, as per the rule, I am qualified. I am qualified as per the rule.
Then this observation of the Supreme Court.
My
goes
lord,
against you.
observation, can it be a precedent? My lord, my,
Obviously, Article 141, if the
141 will
Supreme
not-
Court has
No,
said something,
my lord,
That
to
review petition order is with you.
my lord, may
and
I?
then if you say that this observation is factually incorrect,
Yes,
correct?
yes.
Then the judgment of the Supreme Court will come in your,
My lord,
against
another,
you.
my lord, another.
Can you bring out that judgment?
My lord, another judgment of the,
State of Maharashtra versus Ramdas Srinivas Nayak. EIR 1982. SCC, I do not recollect. Please read that paragraph of the judgment. It says that the counsel nor the litigant can contradict what has been recorded in the order, except he can go to a higher forum, or in the event there is a wrong recording, then in that event, it must be the litigant must approach to the court, same court, before it fades from his memory.
My lord, your lordship, can you pass it over? Let me go. Let me go through, your lordship, pass it.
And very strong worded judgment. It says neither can be contradicted by way of an affidavit.
My
Very
lord,
strong worded judgment.
I have brought some other judgment. Your lordship, your lordship, pass it over. Let me go.
Take up this matter next week.
Oblige.
Go through that. Judgment.
Yes, I will. Oblige.
After arguing for some time, we just are, that council sits for an adjournment till next week. This matter.
Second volume.
Second. Index may be clear. Yes.
It is 1249.
1249. So I was 1243. Very, very close. It says that the court is bound to accept the statement of a judges recorded in their judgment as to what transpired in court. It cannot allow the statement of a judges to be contradicted by the statement at the bar or by an affidavit and the other evidence. If the judges say that in their judgment that something was done, said, or admitted before them, that has to be the last word on the subject. The principle is well settled that the statements of fact as to what transpired at the hearing recorded in the judgment of a court are conclusive of the facts so stated, and no one can contradict such a statement by affidavit or other evidence. Then it says, if a party thinks that happening in the court have been wrongly recorded in the judgment, it is incumbent on the party, while the matter is still fresh in the mind of a judge, as my brother said, before it fades from his memory, to call the attention of the very judges who have made the record of the fact that the statement made in regard to the conduct was the statement made in the court is an error. You can't go through that judgment.
Oblige.
Nothing.
I will convince your lordship. I will try to convince.
Nine.
You are keeping it to next week.
9th April.
Go through the judgment.
Yes. Oblige.
Item 7.
This you have called later.
Item 7.
Yes. What is this matter, sir?
Matter relating to grant of no objection to construct a overhead structure in the municipality road. The Dalmia Cement, the respondent, has got permission from the Rajasthanpur municipality to construct 2 conveyor belt over the Jharkhand.
One fell down.
Well, that fell down. When that has been fell down, the cancellation proceeding has been initiated by issuing notice to the municipality. Your NOC is cancelled and you submit your show cause why your NOC shall not be renewed. That is the notice under Annex 8, page 30. Challenging
Who is for the state?
State is not involved, only the municipality.
So he is representing the municipality.
I am the municipality in Depariolich.
So what steps you have taken against them?
I have initiated against them to cancel their NOC and issued the show cause notice in the same letter why your NOC shall not be renewed.
Now what would happen to that conveyor belt?
That belt, show cause notice has been challenged by the Dalmia Cement before this in the writ petition. In the writ petition, when the matter is pending, the Dalmia Cement produced some technical expert report saying that we are going to construct the
Without any further amount to be charged from you.
No, they are taking free of cost. They are raising construction without paying any license fee. That is, license fee is not the subject. The safety of the general public is the concern in this matter. What happened? Since the municipality has no export.
There was no casualty.
No casualty. In the structure damage, no casualty, but in the factory premises, some casualty. That is a different issue. No, don't say it like this. Not separate. There are 2 accidents.
Time.
Can
Can it be after? Can it be there?
Day after.
Yes.
Saturday.
Saturday.
But
Saturday.